Honorable members, we now move to the criminal procedure, plea discussion, plea agreement, and assistance agreement, Bill 2023, Bill number 19 of 2023, published on the 11th of December 2023. And I now call on the Honorable Attorney General and Minister of Legal Affairs, Senior Counsel Anil Nandlall, to move the second reading.
Thank you very much, sir. Sir, this is yet another crucial legislative intervention as part of our government's effort to modernize the legal architecture of Guyana. It is an output, sir, of the Inter-American Development Bank IDB-funded support for criminal justice. And one of the core objectives of this program, sir, is to ensure greater efficiency in our criminal justice system. This bill seeks to achieve that objective. Like the arbitration bill, sir, it seeks to reintroduce into our legal system, this time in the criminal justice sector, one of the modern features of legal systems across the globe. Again, like the arbitration bill, it is another form of alternative resolution, this time in relation to criminal cases without the resort to a full-blown trial. In short, it allows the prosecution, the defense, and the victim to determine criminal cases. However, it safeguards certain secret principles and concepts to ensure that there is justice in the end, protecting the defendant's interest, the victim's interest, the public's interest, and maintaining the principles of public morality, while at the same time ensuring that criminal conduct is fairly and justly penalized. Plea bargaining, once fully implemented, will drastically reduce the workload in our criminal justice system. It will allow for scarce judicial resources to be spent on cases that are deserving trials, but most importantly, it will save billions of dollars of public funds and bring much needed speed and efficiency in the disposal of criminal cases. The Caribbean Court of Justice, sir, our apex court, when it visited Guyana last year, both in meeting with myself privately and the legal profession publicly, called for a number of modern and innovative measures to be implemented in our criminal justice system. A modern plea bargaining legislation was one of them. We are answering that call tonight. The bill seeks to repeal and replace the Criminal Procedure, Plea Bargaining and Plea Agreement Act, Chapter 1009, Laws of Guyana, which was enacted for the purpose of establishing a system of plea discussions and plea agreements in criminal procedure. The Criminal Procedure, Plea Discussion and Plea Agreement Assistance Bill 2023 addresses the gaps in the current legal framework, and it seeks to protect the rights of individuals and to ensure that offenders are properly prosecuted. The new plea bargaining system in Guyana will adhere to established standards of practice in the United States of America and the United Kingdom. Other jurisdictions, such as Trinidad and Tobago, have been drawing on what is considered the best practices of plea bargaining regimes of the United States and the United Kingdom. This is evidenced by the introduction of Trinidad and Tobago's most recent plea bargaining legislation, Criminal Procedure, Plea Discussion and Plea Agreement Act number 12 of 2017 in Trinidad and Tobago. It is well established and accepted, sir, that the most prolific plea bargaining in common law jurisdiction occurs in the various states of the United States of America, both at a federal and state levels. Recent studies maintain that plea bargaining in the United States continues to work effectively as a tool in the criminal justice system, with more than 95% of all settled criminal cases being resolved due to plea bargaining. Anyone, sir, watching American television, especially the law series like Suits and Law and Order, CSI, etc., would quickly discern the important role of plea bargaining and the prevalence that plea bargaining plays in that legal system. One expert opined as follows, sir. I quote, plea bargaining is an incredibly effective tool for increasing efficiency in the criminal justice system, as without it, judges and lawyers would be flooded with caseloads, rendering them incapable of doing their jobs effectively. And that's the position with our criminal justice system. An extraordinarily heavy workload, both on the system and on the human resource available. Plea bargaining, sir, as you may know, sir, was once considered repugnant in the United Kingdom. In fact, at common law, one could possibly have been charged with perverting the course of justice for engaging in what we know as plea bargaining. That is now history. The plea bargaining system is now entrenched in the United Kingdom. In its present form, it is regarded as being a fair and efficient system. The system in the UK seeks to enhance the administration of justice while seeking to place considerable emphasis on rehabilitation and restorative justice principles. It is now also a permanent feature in the criminal justice system across the Caribbean. In February 2020, Chief Justice Ivor Archie of Trinidad and Tobago, speaking on the Trinidad legislation, posited as follows, and I quote, Now plea bargaining agreements, as I am sure you know, are just one part of the overall strategy in the criminal justice system to improve efficiency and reduce backlogs while ensuring the protection of individual rights and rehabilitation of offenders. It is our belief that the legislation as it now stands will effectively achieve that balance. Plea agreements avoid trials. They re-traumatization of victims and allow for a harmonious approach to the admission of guilt for the promise of a reduced sentence. If we are to imagine a world where there are no unreasonably lengthy trials that span years and years, where by the time of the conclusion, the defendant may have already served his or her sentence and more, but imagine instead an amicable discussion between attorneys on either side of defense with the aim of seeking both the interest of administrating justice and considering the impact on the defendant and the victim. And such is the promise of plea bargaining agreements that is codified in the legislation, unquote. In order to guarantee fairness, transparency, and adherence to the principles of freedom of choice, it is essential that certain key elements are present during plea discussions and or agreements and the subsequent plea hearing process. Additionally, these measures are necessary to ensure that the public interest is respected and the appropriate sentences are imposed on criminal offenders. One principle is that the accused should not be forced or pressured into pleading guilty. The agreement and subsequent plea must be made willingly and with full knowledge, which means the accused must always be informed of their rights and given the chance to consult with an attorney at law. The second requirement is that the prosecution must possess knowledge of and take into account all pertinent factors when choosing whether to participate in plea negotiations. The third requirement is that the prosecution must possess knowledge of the potential course of action to which the accused may consent. The fourth requirement is that the judge must consistently investigate and confirm that the negotiations, agreement, and plea are the outcome of a well-informed process, where the accused is fully cognizant of their rights and has been given ample time to obtain legal counsel. The fifth requirement is that the procedures for plea bargaining hearing must be unambiguous and all parties must be afforded a fair opportunity to present their arguments. The sixth principle entails granting each party the right to withdraw from the process and the agreement under justifiable circumstances. If it can be demonstrated that a plea was acquired in an inappropriate manner, such as fraud or serious misrepresentation, then the plea should be invalidated. Both the prosecution and the accused should have the right to appeal in two specific circumstances. A, where the court rejects a plea bargain, and B, when a sentence is imposed in breach of a plea agreement. So that's a limited scope of challenge that is available in the plea bargaining system. Sir, as I stated, we enacted a plea agreement act of chapter 1009 in 2008, but it never yielded the success that we anticipated, and for many reasons. In my view, it had a very fundamental structural deficiency in that it only allowed for plea bargaining to take place after a charge is instituted. This bill allows for plea bargaining, as I will demonstrate, to take place even before a charge. The act also was deficient in the concentration of responsibilities. Rather than center the responsibilities within the remit of the Director of Public Prosecutions, who is in charge of all prosecutions in the country, that act centers the powers in the judiciary. And that, I believe, sir, was a fatal flaw. And there were other limitations that afflicted that law, and a combination of them all rendered the act underutilized to a large extent. In fact, as I stand here, I could hardly recall a case where the act was used. All of that, sir, was taken into account. We looked at plea bargaining bills across legislation across the Caribbean. We examined the position in the United States. We examined the position in the United Kingdom. And of course, we examined our local law. And having studied all the various models out there, we drew from them all and crafted this bill. Mr. Speaker, the bill before this House today seeks to transform the criminal law system by modernizing the existing legal framework of plea bargaining in Guyana. The purpose of the bill is to ensure a prosecutor and an accused person, which includes a person suspected of committing a criminal offense, and the defendant in proceedings before the court for criminal proceedings, whether on his own or represented by an attorney at law, to engage in plea decisions aimed at arriving at a plea agreement. Under a plea agreement, the accused agrees to plead guilty to a specified offense or undertakes to perform any other obligation contained in the plea agreement in exchange for the prosecutor's undertaking to take a particular course of action. I pause here, sir, to give you an example that all of us may be able to relate to. You will recall, sir, the Lusignan massacre case. In that case, the DPP didn't have this bill at her disposal and didn't have this bill, so was unable, before charging, to strike a plea deal with one of the accused persons. A deal was eventually struck, but after the person was charged. And my learned friend, Comrade Ramjatan, would know that once you're an accused, and even if you testify, your evidence lacks certain legal credibility, because you have an interest to serve. You have so many things that the jury will have to be specifically be directed to treat your evidence with extreme circumspection and care. And that's all because you were charged, and you're moving from a co-accused now to a principal witness for the state. Here, this bill allows the DPP, even before instituting charges, to at the level of the investigation, to begin to work out a plea deal. So you take one of the cases where you don't have an eyewitness, you have now the ability not to be able to charge all of them. Use one of them as a state witness, strike a plea deal with that one, and make that one a principal state witness against the others. That's the type of flexibility that this bill allows. It enables the acceleration of trials, the alleviation of congestion in criminal justice system, the inclusion of victims in the decision-making process, and the preservation of judicial discretion throughout all stages of the process. The bill, sir, is quite a big bill, as expected, so I will summarize the main tenets of the bill. Clause 2 provides for an interpretation of certain terms used in the bill, which includes improper inducement, victim, and relative. So under the previous law, well, the current law, you had very narrow definitions. In this bill, we have expanded those definitions. Experience has shown that prosecutors have been known to overcharge or engage in charge bargaining simply to coerce the accused to plead to a lesser charge. They have also been known to threaten an accused person to charge him with a more serious offense which is not grounded in evidence, or to charge a family member if the accused does not plead guilty, or threaten an accused that they intend to seek severe sentence if he goes to trial. These matters are not addressed in the definition provided in the current legislation. They are provided for in this bill, and they are all offenses and are protected against, so that you don't have a prosecutor taking advantage of the defense. Section 2 of the current legislation, for example, defines, and I'll not go into all of that, but what I attempted to do here is to go through the definition of the current bill and the extant law to show how the current bill is wider in its ambit and amplitude, and therefore a far more modern and progressive bill than the current state of the law. Part 2 of the bill provides for certain procedural matters relating to plea discussions. The procedure is contained in clauses 5 to 12. This part requires plea discussion to be held and a plea agreement or assistant agreement to be concluded at any time before conviction, including before charges are instituted. Additionally, before entering into a plea discussion or reaching a plea agreement, a prosecutor is required to acquire the written authorization of the Director of Public Prosecutions. So you don't have rogue prosecutions going on. The Director of Public Prosecutions must authorize the plea deals or even the commencement of the negotiations. A fourth objective of the bill is to make it illegal to utilize inappropriate inducements in order to persuade an accused person or suspect to take part in a plea discussion. This part also provides certain safeguards for the accused person. A prosecutor's primary duty is to seek justice, not merely to convict. Therefore, the bill seeks to prohibit a prosecutor from participating in plea discussions in certain circumstances. For example, a plea discussion that requires an accused to plead guilty to an offense that is not disclosed by the evidence or inadequately reflects the gravity of the provable conduct of the accused. So when you go to negotiate or to do plea bargaining, you are to plea bargain in relation to the offense that is disclosed on the evidence in the file. So you don't use a heavy hand, as the authors in the textbooks say. You negotiate only in relation to the provable offense, and you don't exaggerate the offense in order to get the accused to come down to a better deal. In other words, you go in a store and the man jack up the price as soon as he sees you, but he gives you a discount when you buy the product. And the discount is maybe less than what he was selling it for in any event. The same principle is captured here. This part also prohibits a prosecutor from initiating plea discussions with an unrepresented accused person or suspect, unless the prosecutor informs the accused person or suspect of certain rights, including the right to be represented by an attorney at law. Every prosecutor has a duty to provide the suspect or accused person with a written summary of the evidence against the suspect or accused person in circumstances where plea discussions are initiated, both before charges are laid as well as after charges are laid. The final clause of Part 2 sets out the procedure to be followed by the judge or magistrate upon first appearance of the accused in the court. That clause sets out a statutory right for an accused person to be informed of his right to enter plea discussions with the prosecutor and to be represented by an attorney at law. So you advise the man of his right to be represented by an attorney at law. If he waives that right, that's a matter for him. But you are duty bound as a prosecutor to inform him of that right. And implicit in that is to allow him the opportunity to retain and instruct a lawyer of his choice, which is a right guaranteed by the Constitution anyhow. Part 3 of the bill, sir, provides for victim impact statements as contained in clauses 13 and 18. So this pre-bargaining agreement that the bill seeks to legislate ensures that the victim play a serious role in the entire process, as the victim is obviously the most affected party by the criminal conduct. And here, unlike in a conventional criminal trial, apart from the victim's evidence, really the victim interest is not really taken into account thereafter. It's only the evidence and the nature of the offense. Here the victim is allowed to play a part, and the impact that the offense had on the victim is a factor that is taken into account when the process unfolds. Prior to finalizing any plea bargain with an accused individual, the prosecutor is obliged to solicit the input of the victim or a relative of the victim if the victim is not accessible. The victim may be dead, so resort is had to a relative. In order to effectively combat crime, it is crucial to uphold public confidence and ensure that agreements are not made without considering the victim's perspective. Modern legislation requires a prosecutor to seek and obtain a victim impact statement from the victim or relative even before a plea agreement is concluded. Part 3 of the legislation in Trinidad and Tobago, for instance, outlines a thorough approach regarding victim impact statement and involvement of a victim or their relative in plea discussions, agreement, and court process that follows, including the sentencing of the accused if the plea is accepted. Section 8.1 of the Guyana's current law obliges the prosecutor to consult with and obtain the view of the victim or relative of the victim before concluding a plea bargaining. However, the term relative is narrowly construed to mean the spouse, including a reputed spouse, parent, step-parent, child, stepchild of the victim. In the absence of these persons, there is no allowance for any other relative to be consulted. Additionally, Section 11(1) of the current law states that the court shall in open court seek the views of the victim or relatives of the victim before recording the terms of the agreement and passing sentence. Section 11(2) stipulates that where the court considers it prudent to do so, the court may retire to chambers to hear the views of the victim or relative as the case may be, and this is done in the presence of the accused or his attorney, if any. The current methods of plea bargaining and sentencing demonstrate that the parameters outlined in the current act are restricted and fail to offer a sufficient opportunity for achieving restorative justice objectives. It is for this reason that the victim impact statement model was adopted in the bill for the purpose of expressly allowing the victim or relative to set out the impact which the offense has had on him or her. Part 3 of the bill imposes a duty on the prosecution to inform the victim of his or her right to provide a victim impact statement. It requires a victim to provide a victim impact statement explaining the physical or emotional harm, financial loss, or other impact the offense has had on the victim. Additionally, this part allows for the particulars of the victim impact statement. Clause 14 is restrictive as it restricts the content of a victim impact statement. According to Clause 14, a victim impact statement shall not include a restatement of the offense, as that's obviously not necessary, criticism about the accused person, that is not necessary, or the victim's opinion about the type or severity of the sentence to be imposed. That is not the prerogative of the victim. Clause 15 of the bill makes provision for relatives of the victim to provide a victim impact statement in circumstances where the victim has died, is ill, or is otherwise incapacitated or cannot be found. This part further provides for the procedure to be followed in circumstances where an impact statement is being provided by a victim who is a child. It also seeks to make provision for a duly authorized representative of a business that has been a victim of a crime to provide a victim impact statement on behalf of the victim, the business, sorry. The final clause of this part sets out the duties of the prosecutor in respect of the victim impact statement and the victim. The prosecutor is required to ensure that the victim impact statement complies with the requirements of Clause 14. If the statement is contrary to Section 14, the prosecutor must remove that material from the victim impact statement before filing it in court. The prosecutor is required to serve the victim impact statement on the accused person or his attorney at law before it is filed in the court. Part 4 of the bill, sir, provides the procedure to be followed in respect of plea bargaining, plea agreements, and plea agreement hearings. This part consists of clauses 19 to 27. Clauses 19 and 20 provide for the form and filing of plea agreements for a represented person and an unrepresented person, respectively. Clause 19 of the bill provides for the circumstances where a plea agreement is concluded between a prosecutor and an attorney at law for an accused person or suspect, and provide a list of documents which shall accompany the plea agreement and which must be filed with the clerk of the court or registrar, as the case may be. Clause 20 of the bill provides for the circumstances where a plea agreement is concluded between a prosecutor and an unrepresented accused person or suspect, and provides a list of documents which shall accompany the plea agreement, which must be filed with the clerk of court or registrar, as the case may be. Clause 21 provides for the procedure to be followed upon the filing of a plea agreement. It requires a plea agreement hearing to be held within 28 days of the date of that plea agreement is filed. So I spoke about the speed, and you see it here, sir. No long delay. Once the plea agreement is filed, within 28 days, we must have a plea hearing. It is important to note that if a matter is not set down before the court for a plea hearing within 28 days, the prosecutor, the attorney at law for the accused person, or the accused person may make an application orally or in writing to have the matter set down for a plea agreement hearing. Here is another mechanism that is established which allows either the prosecutor, the accused, or the accused or the lawyers to push the process along. Clause 22 of the bill, sir, provides that where a plea agreement is filed before the commencement or during the conduct of committal proceedings, but before the accused is committed to stand trial in the High Court, the magistrate shall inter alia cease conduct of the committal proceedings if the proceedings have commenced and order the plea agreement hearing be transferred to the High Court for determination. Where the matter is transferred, the magistrate may grant bail to the accused person pursuant to the Bail Act of Chapter 2022. So sorry if you're doing a preliminary inquiry in the magistrate's court and the parties decide that they want to enter into a pre-deal, the magistrate is to stop the PI immediately and transfer the matter straight over to the High Court for the pre-deal, the plea deal to be sealed. Clause 23 of the bill imposes a duty on the Director of Public Prosecutions to prefer and file an indictment within a specified time frame in circumstances where a plea agreement is filed before the commencement or conclusion of the committal proceedings. Here again, there is no delay. The DPP, once the plea agreement is filed and the magistrate aborts the PI, the DPP must prefer the indictment within a specified time. Clause 24 of the bill provides the procedure to be followed at a plea agreement hearing. The prosecutor is required to disclose certain information to the court, and the court is required to make certain inquiries of the accused at the plea hearing. This part further sets out the procedure when a plea agreement is accepted and if the accused person withdraws from the plea agreement or assistance agreement. If the court accepts the plea agreement, the accused person shall then plead to the charge. Part 5 of the bill provides for the general and miscellaneous provisions. It consists of clauses 28 to 38. This part provides that an accused person or the DPP may appeal to the Court of Appeal where the court has rejected a plea agreement. So, if the two parties have agreed to plea and the court rejects that plea agreement, that is a ground of appeal. Clause 30 and 31 provide the grounds upon which an accused may withdraw from a plea agreement and the grounds upon which the DPP may seek leave of the Court of Appeal to have a plea agreement or conviction set aside. Additionally, Clause 33 of the bill provides that an offer to enter into a plea agreement or statement made in connection with the offer, a statement made during plea discussions or plea agreement hearing, or a plea agreement or a guilty plea which is later withdrawn is not admissible in any civil or criminal proceedings against the accused person. So if there is a breakdown of the plea agreement or the plea discussion, or even if the plea is later set aside, the plea agreement is later set aside, and this accused person now has to go to face a trial, none of the things that they discussed in that plea agreement, the guilty plea, nothing of that type is admissible in a court simply because it would obviously prejudice the fair trial of that person. Further, this part provides for the sealing of records, the minister power to amend schedules and make regulations, etc., under the bill. And of course, the bill repeals the current Plea Bargaining and Plea Agreement Act, Chapter 10:09. So, sir, in a nutshell, those are the essential elements of the plea bargaining bill that is before us. It's new to Guyana, but it's something that is extant throughout the Caribbean, throughout the Commonwealth, well entrenched in the United States of America and the United Kingdom. And we have moved from a position where 40 years ago, if the DPP were to try to strike such a deal with an accused person, or vice versa, an accused person approaching the DPP to try to negotiate something of this type, it would have amounted to perverting the course of justice. It would have amounted to interfering with the course of justice. So far now, the law has moved whereby the parties can now sit, the state and the accused person and the victim can now sit at a table and work out an appropriately plea arrangement that will protect the victim's interest, protect the state's interest, maintain the aversion that society has against criminal conduct, ensure an appropriate sanction is imposed, while at the same time delivering justice in the end. There is one amendment, sir, if you will permit me to speak on, and this amendment is to remove from the plea bargaining process properties which may have been acquired by criminal conduct, from the proceeds of crime, etc. Those properties shall not be, or properties that have been forfeited as being coming from proceeds of crime or being used in criminal process, etc. Those properties or their forfeiture shall not be the subject of plea bargaining. So if we seize a property, and we have now revamped our law in that regard, we are now going to do a lot of forfeiture in criminal proceedings now once we get a conviction. We have never been doing that historically, but we have now revamped the law, and we have a wide repertoire of statutory powers now that can be activated to go after properties acquired from crime. This plea bargaining bill accepts that. It does not allow for plea bargaining to take place in relation to properties that either have been the subject of forfeiture proceedings or are likely to be the subject of forfeiture proceedings on the ground that they were acquired through criminal enterprises or they were acquired as proceeds from crime. So, Mr. Speaker, that is the plea bargaining bill which I commend to this House. Thank you very much, sir.